All right. Well, good afternoon, everyone. My name is Andy Jones, and I have the privilege to be the incoming 2022 DAYL president. But today, I have the illustrious privilege to be presenting on the new rules today with the Honorable Judge Monica Purdy and Ms. Kirsten Castaneda. Before we do some brief introductions and get down to business, I want to let you all know that Sherry will be putting the CLE number for the course in the chat bar. So look out for that. And hopefully I'll remember to say that at the end of the course too. Also, if you'd like to ask a question during today's presentation, there are a lot of you out there in Zoom land. So please use the question and answer function. I will be monitoring that, hopefully being able to pull your questions in. And if not, I'm confident that all of us would be happy to take your questions at another time, give out your email and give out our emails and all of that. So let us get started by giving some brief introductions. Again, I'm Andy Jones. I'm a plaintiff's personal injury lawyer. I'm a practitioner, so that's the perspective I'm bringing today. I am not an appellate lawyer. I'm a very happy trial lawyer. Next up on the panel, we have the Honorable Judge Monica Purdy. She is the presiding judge of the 95th Judicial District Court in Dallas County. Judge Purdy hears civil matters ranging from personal injury cases to complex commercial litigation. She is the first African-American to serve on the 95th District Court in its nearly 100-year history. Prior to serving as judge of the 95th Judicial District Court, she was unanimously appointed as the associate judge of the Civil District Courts in 2013. Her previous judicial experience also includes as a municipal court judge for the city of Dallas. Her legal career included representation of Fortune 500 clients in litigation and collections disputes, as well as starting as an associate and then becoming a partner at a national law firm. Judge Purdy has an unmatched passion and commitment to educating the public about the importance of voting, issues affecting justice, and our courts throughout the Dallas-Fort Worth Metroplex. So, big round of silent Zoom applause for Judge Monica Purdy.
Thank you. Thank you for that introduction, Andy.
You're welcome. And turning to our third panelist, our appellate lawyer extraordinaire, Kirsten Castaneda is an appellate extraordinaire, partner and chief diversity officer at Alexander Dubose Jefferson. For 25 years, Kirsten has worked with trial lawyers in federal and state courtrooms in cases that raise issues critical to businesses and industries across our state and the nation. In tandem with her trial level work, Kirsten continues to draft briefs and formulate strategy for mandamus proceedings and traditional, interlocutory, and permissive appeals in the Texas Courts of Appeals, Texas Supreme Court, and the Fifth Circuit. Kirsten has been listed in Best Lawyers in America for appellate practice, Super Lawyers Appellate Practice, and voted one of D Magazine's Best Lawyers in Appellate Practice. Kirsten is an active member of the American Bar Association's Tort Trial and Insurance Practice, and my personal favorite, she's on the Pattern Jury Charge Oversight Committee and serves on the Court Rules Committee as the chair of the Appellate Subcommittee. Kirsten, your silent round of Zoom applause.
Thank you so much.
Outstanding. Well, to start us off, before we dive into the nuts and bolts of the rules and what we're going to talk about, I'd like to toss to Judge Purdy, who just sat a live and in-person living, breathing jury to kind of give us an update on jury procedure, what's going on in the Dallas courthouse, and what she can tell us about that.
Sure. I'm happy to do so. So yes, I'm currently in a in-person jury trial as we speak. I am the only one in my courtroom with my bailiff far away from me right now. So therefore, no mask for this particular presentation. But here at the George L. Allen, we have resumed in-person jury trials. We are picking up to about 3 jurors each day, 3 jury panels each day, and beginning the process of getting us back to in-person jury trials and trying to, of course, tackle the backlog that has been created by the pandemic. I think we've done a great job of basically trying to make sure that we keep not only our court staff safe, we're keeping the jurors that actually show up in the middle of a pandemic safe, and we are keeping the parties safe. So the code level has moved in Dallas County from red. Seems like we've been at red for a very long time. We're now at orange. And so things are looking brighter. Hopefully, we hope to be back fully operational by January 1st, but that is going to depend on how numbers continue to look here in Dallas County. So we're here. This is probably my second trial this week. So I believe that things are ready to go here at the courthouse.
That's wonderful news, Judge. It's really important that we're able to get that going again. Thank you for everything your court staff, and that Dallas County is doing to make that possible. So, and thank you very much for the update. So today's topic is about the new rules of civil procedure, and no one on this phone call thinks the new rules were from 1999. We all know that January 1, 2021, the Texas Supreme Court made some serious changes to the discovery rules and to certain elements of the rules of civil procedure. We're not going to talk about them all. We're going to talk about a couple of them broken up into chunks and welcome your questions. Turning to the first ones we're going to talk about discovery rules TRCP 47 and TRCP 169. And in brief, Rule 47 and 169 deal with the rise of damage caps, that expedited actions are now no longer $100,000 cases, they're $250,000 cases, and there's some new required pleadings under Rule 47. So continuing on this theme of COVID-based backlog, I did want to toss it over to Judge Purdy and ask, have you seen the change in this jurisdictional cap have any impact on your docket, or do you have any thoughts about how it will impact your docket in the future?
Well, as you can imagine, I think I just gave the report on, we're back to in-person jury trials. This is my second one seated this week. We, of course, have an enormous backlog. We are trying to do what we can to get people to trial, their constitutional right to have a trial, and trying to figure out the way in which to best do that. Expedited actions under the old rules, they certainly were plentiful in our courts. So I don't know that I've seen a whole bunch that triggered this new jurisdictional limit just yet. I don't know if they've worked their way through the system because, as you can imagine, we are calling to trial. The case that I called to trial today, I believe, is a 2019 or 2020 case. So we're still a few years behind in getting our cases to trial. But of course, I think the premise behind this amendment to this particular rule is to try to get these smaller types of cases to trial quicker and to make sure that discovery costs are lowered in trying to get there. So that's a long way to say that I haven't seen a whole bunch of these cases just yet before the court, because I don't know that they've worked their way through the system just yet.
Okay. Kirsten, you and I have had the privilege of doing this panel once before, and we came up with some nightmare scenarios that could or could not have happened. What have you seen in your trial and litigation support practice as far as Rule 47, 169, and this new jurisdictional cap?
Well, first of all, there's a new pleading requirement. And so people who aren't necessarily aware of that may fall into the trap of not including the required information in their pleading, which I believe, stops you from starting the discovery process. So it just slows things down. I think also the idea that every case filed in a county court at law is susceptible to being an expedited action. It doesn't necessarily mean every case will be, but unlike district courts, where you could have a very small subset of cases filed in district court end up falling within the expedited action process, it's flipped in county court. I think many, if not most, of the cases that are filed in county court are going to fall into this expedited action process, because the jurisdiction for county courts at law mirrors the prerequisites for falling it, or the triggers for falling into expedited actions. I'm not sure exactly how county courts at law are going to handle the situation if, 70% of the cases in their courts are expedited actions. I am sure that the county court at law judges will do their best to rise to the challenge. I have no doubt about that. Judge Bellin spoke at Dallas Bar Association's bench bar at the end of last week and did a great job of updating everybody about how the county courts are working to clear their backload, move cases forward, where cases are, needing a jury trial, take advantage of the fact that, there are 3 board veneer panels available a day for judges to avail themselves of. But it's not going to do any good to clear even the backlog from the pandemic if then you just run into the bulwark of every single case has to be tried in a really short period of time, and you can only have 2 continuances for, a very short amount of time as well, 60 or 90 days. I can't remember how long it is. And then you got to go, and the statute requires you to do that. So we'll see how this works, but just be aware that if you are filing into county court at law, or you're served with a petition filed in county court at law, you better check to make sure that you are not in the expedited rule, because otherwise that case is going to move like a bullet train.
And speaking of moving like a bullet train, Rule 169 not only has jurisdictional caps, but it also has discovery limitations. And what was really interesting to me, my practice is primarily medical malpractice. There used to be an exception for med mal and land title and in cases that multiple experts, complicated issues. That's not the case anymore. So practitioners out there need to be very careful about pleading in or out of this, especially if your case is not something where you only need 2 experts and only 8 hours aside for trial. Tell me how you can do a med mal in that time. I don't know. But Kirsten, correct me if I'm wrong, but these expedited actions also don't have an enforcement mechanism for courts to use or anything like that if you don't meet the deadline. Am I right about that?
Right. There's no actual penalty set forth in the statute. So it's difficult to understand exactly how this is going to work. And I'm sure that it will vary case by case and court by court. I do think that it is noteworthy that the Office of Court Administration here in Texas keeps statistics on various types of cases that are pending in various levels of courts and how courts are moving their dockets. And different judges have different, different reactions to that and how much they pay attention to it. In places where elections are not maybe as close as in other places, it may be less of a concern. But I will say that one of the things that the Texas legislature began to do at a certain point in the past, 15, 20 years or so, is to use the OCA statistics of the length of time that it was taking courts of appeals to dispose of cases. I believe I can't remember exactly where the timeline started. But anyway, it's length of time thing to actually determine budget for the courts of appeals. And ironically or nonsensically, I don't know which word would be more appropriate, the legislature would give less budgetary funds to courts that were falling behind, which is nonsensical because if you're falling behind, you probably are falling behind because you don't have adequate staff attorneys and other assistants to help you. But anyway, I don't know if that kind of thing is on the radar for the Texas legislature. If county courts at law start getting way far behind in their dockets and the expedited actions are languishing, and the Texas legislature doesn't like that because they created the expedited actions process, will they take action like that where it's not a true enforcement, it's not in the statute, but county courts obviously are funded by the counties as opposed to the state level, but is there anything they could do that might sort of punish courts for doing this? So we'll just have to see how it plays out. But yeah, there's no enforcement mechanism. You mentioned the discovery, the limited discovery. I will say when the the caps for the expedited actions got bigger, the Texas Supreme Court did make commensurate changes to expand the discovery a little bit. But like you say, it didn't expand it very much. And, instead of 6 hours of depositions, you get 20. But that's not a huge increase. And like you're saying, for a medical malpractice case,
still can't move for certain summary judgment.
right.
I could go on. I interrupted.
Right, no, and also let's mention family code cases are getting sucked into this as well. And so we have a whole, section of the bar that didn't have to worry about this stuff before. And now they're having to learn all these rules that never applied to them in cases that can be incredibly complex and, incredibly important. So we'll have to see how that works out too.
I just wanted to add that I think, sort of the timing on some of these amendments. Of course, I sit in a district court, so as Kirsten mentioned, I'm probably going to have smaller amounts of these types of cases filed in my court as opposed to a county court at law. However, the county courts at law, they are coupled with the whole eviction moratorium. Those particular cases are what is really overloading their dockets. And then to have these expedited actions to try to be determined, to be figured out, is also going to be problematic for those particular courts. And the expedited actions have to be set for trial 90 days after that discovery period ends, and you can only get 2 continuances. From a court's perspective, I think it's going to be difficult to manage that particular docket management style, compounded with what the pandemic has posed on the courts.
Because this is me and I do this, so Sherry Harris is probably spinning in her chair right now. Can we just jump off the script for a second and just kind of, Judge, can I just get your take to the extent you're able to share on your feeling regarding the legislature and the court making these changes? Ultimately, do you feel like that they're increasing complexity and making traps for practitioners? I'm not putting words in your mouth, but I'm kind of going in the direction of, are we Admiral Akbar and this is a trap? Do we think this is improving the performance of practice? How do you put this in context for yourself?
Well, I guess I tend to probably be more of a person. Let's look at this with the glass half full.
Okay.
I think that most people that tackle these types of issues are trying to be more efficient. How can we help? How can we streamline a process? So I believe that is the intent behind it. But I think sometimes when, much like anything, when you don't have practitioners at that table to obviously point out problems with the imposition of some of these rules, as Kirsten has mentioned, family law, how does that change their particular practice? How does that change the management of their docket? So I think it's really imperative. I think the intent is there to think this will be more efficient. This can move cases quicker through our courts. But when you don't have practitioners basically at that table to obviously point out any pitfalls with this, then it becomes problematic. So I don't know that we have a holistic approach as to the correct people sitting at the table. Or I want to also make sure that the people that are listening to this webinar today know that they have a voice in actually pointing out any problems that they have with the rules. I know Kirsten and I talked about that a little bit yesterday, as well as Andy, in preparation for this. And so it may be a good time, Kirsten, to let individuals know how they can chime in if they are seeing actual problems in the logistics of how these rules actually work out.
Yeah, thank you. The State Bar, as Andy mentioned, has a court rules committee that Andy actually, I believe, is homing right now. And the court rules committee works for you as members of the State Bar. We do not have the power to change the rules, but we do have the ability to study rules, propose amendments or changes, provide explanations of why we believe the amendments or changes are necessary. and send those proposals to the Texas Supreme Court directly, to the rules attorney there. And the Texas Supreme Court can then act on that. Generally, the way that they act on that is referring the matter to the Supreme Court Advisory Committee, which is the sort of delegated body that they rely upon to hash out what amendments would look like, and whether they're necessary. And that they do a very good job, I think, of making sure that the committee is comprised of practitioners from both sides of the bar and judges from all levels of the judiciary, and the different constituencies such as, probate, family, criminal, civil, and then all levels of the courts, so that everybody hopefully is represented at the table, although obviously they may not be, represented proportionately, but everybody sort of gets a voice in crafting the amendments. So sending an email to the Court Rules Committee, and I believe that in addition to, Andy and myself, who you now know are on the committee, I believe there's committee information on the State Bar website. So even as we change who's doing the work, you can always email those folks, or the rules attorney at the Texas Supreme Court, who is a good liaison between a lot of different constituencies, to pass along concerns that practitioners have or suggestions for changes in the rules. So as we're going through these amended rules and we're seeing how they play out, we find problems or ambiguities, those are really great resources for you to be able to suggest changes and share your experiences, because I will tell you for a certainty that having stories from practitioners of how the problem is impacting their practice and how it is impacting the practice of their colleagues is a lot more powerful a motivation for the Texas Supreme Court to actually refer something to the advisory committee than just we see an ambiguity and it may cause a problem at some point.
Sure.
So those anecdotal things are really important to share. The other thing to be aware of is when the email comes across your inbox from the State Bar of Texas or the Texas Supreme Court saying, hey, we've proposed rule amendments and there's a comment period, please review the amendments and send us your comments. Don't just put that in your trash. Take a look and see what's being proposed as the amendment and think about how would this impact me, and would it be a problem? Do I even understand the rule? Do I understand what's being changed about it? This seems really unclear to me. That's the best time for everybody to pipe up and say, hey, this is not going to work and here's why. Or to say, hey, great job, but if you were trying to do this rule doesn't do it. Those are the best opportunities for you to have a voice. So don't throw those away and comment during the comment period.
So those are powerful ways for practitioners to get involved. And I really counsel and encourage young lawyers to get involved, even though your name isn't on the door or on the letterhead. The rules attorney, rules attorney's our age. She will read it. And the Supreme Court cares a great deal about what practitioners of every age and stage of practice care about. So please take Kirsten up on her invite. And by the way, if you're interested in the Court Rules Committee, come on down. But speaking of ambiguity and how are you intending to do that, let's talk about initial disclosures. Because now it's no longer an RFD, a request for disclosure that you could put in a petition or an answer. Now Rule 194 has been federalized, at least that's what I think what's happened. And now you have required disclosures. To summarize the basics of the rule, Rule 194.2a, your disclosures are due 30 days after filing of the first answer. Okay, so maybe you should just put that in a scheduling order instead of dealing with that. But it's there. But that's now the new rule, and these are required. You don't have to wait for a disclosure request. You have to get them out. Rule 194.2b now requires you to disclose documents that you're going to use to support or refute claims, except those that are for impeachment. So you've got to put out your evidence out there. You also have to put out your legal theories and factual information. And the old exemptions they're much smaller. Initial disclosures are in every case now, unless it's for administrative record of some kind of forfeiture or a petition of habeas corpus. So these are everywhere now, and they are required. Personally, for me, like I said, I put these in my scheduling orders now, so I don't have to deal with the deadlines of you answered when and how. And that because this sounds a lot like Federal Rule 26, that's the way I've chosen to begin practicing on dealing with that. And so I recommend to practitioners out there to treat this now like it's a federal case. And if you don't know those federal cases or those federal rules, time to brush up. But I wanted to turn it over to Judge Purdy because I feel like this is the new frontier for motions to compel or motions to strike undisclosed evidence.
I think so too, and I do agree with the statement that this particular rule has been federalized. So it basically mimics that federal rule. I haven't seen a lot in our motions to compel just yet, so they may be coming down the pipes as well. You know, you now have disclosures in family law cases. I know we talked sort of in preparation that I had a good friend who is a family law practitioner that was really concerned about this particular rule because, as you can imagine, early on in a family law case, you might think your case is one particular way, and as you go through your particular marital dissolution, you find out maybe a spouse has hidden property, has bought property without your knowledge and different things. And that obviously changes the tenor of your case, that you thought this was just going to be a marriage dissolution, a property division, and you find out that there's property that the spouse, your client at that time, did not even know about. So I think it changes it quite a bit. The only thing that I can say in terms of the documents and exhibits that you have to turn over to sort of support your claims early on is, you know, do the best that you can with what you have, because, you know, it's just scary because, you know, things don't develop until you are actually in litigation.
Well, and the other thing about this that I think is important is that there is, like you said, with the family law cases develop, this also is your business litigation case, where at the beginning you plead everything breach of contract to theft liability. And then by the end of the case, it comes down to 3 causes of action. You know, how does that change? How does that disclose? How do your disclosures look? Kirsten, isn't there a provision about what versions you can use and what versions you can't use?
Yes, there is actually, and Judge Purdy's question that she had received actually pointed this out. In Rule 194.6, it states that a disclosure that has been changed, well, certain of the disclosures that has been changed by an amended or supplemental response is not admissible and cannot be used for impeachment. And the two that applies to, I'm just going to scroll up here so I don't screw it up, is the legal theories and factual basis of the claims and defenses and the amount and any method of calculating economic damages. So I think the point of Rule 194.6 is to encourage people to go ahead and disclose those 2 disclosures, you know, as early as possible when you're having to do your required disclosures, at a time when your case is not very well developed and you may not have all the information you need to accurately describe what legal theories and factual bases you're going to be relying upon at trial, and without really knowing exactly what amount and method of calculating economic damages is. And so if you end up amending and supplementing those, the earlier superseded answers under Rule 194.6 should not be admissible, even for impeachment purposes, you know, to try and show you're just changing your theories and you don't really have a very good claim. The thing to remember, though, I mean, that points out, is that on the one hand, you know, the normal rules about amendment and supplementation of discovery applies. So you're having to make these disclosures very early on. You're not required to disclose stuff you don't have yet or don't know yet. You're not going to get, theoretically, you're not going to get penalized for that, for not doing that. But you do have a duty, as always, to supplement your earlier responses reasonably promptly after discovering that the earlier response is incomplete or misleading. And so because these are required disclosures now, that you don't wait for a request, you're not in the position anymore of being able to say, well, nobody ever requested disclosures, so I didn't have to do that. You basically are in a position now where you need to calendar tickler reminders for yourself all along the way, and especially during the heated part of discovery where depositions are happening and productions are happening and all that kind of stuff is coming to your attention and document review is going on, that you need to not only look back at what requests for production were made to see whether you need a supplement or interrogatories or admissions, but also everything in this rule that you're just required to voluntarily disclose on your own volition. You need to be supplementing that as you go along, because otherwise Judge Purdy is going to get a motion for sanctions for automatic exclusion because you didn't supplement your initial disclosures. You're not in trouble because you didn't provide the information at the beginning, but then when you knew you had a duty to supplement, you didn't supplement. And now it's, less than 30 days before trial, and you want to rely on this thing that you never provided. And that's especially true when now the required disclosures include a copy or description by category and location of all documents and tangible things in your possession, custody, or control that you may use to support your claims or defenses. So if all of a sudden a really great document falls on your desk during a deposition and you forget to supplement your required disclosures to give that back to the other side, is it enough that it was disclosed at the deposition or not? And there's case law that can support you, but do you want to be having that debate? And do you want to have to explain to your client why you're spending your client's money on that when all you had to do was just supplement your required disclosures, So this is a great rule to the extent that it makes discovery more what it's supposed to be, which is let's all just give each other everything we have that we're going to use or might use, and let's let the chips fall where they may. Everybody deal with it. But it's also a potential trap, and it's a potential basis for people to ask for exclusionary sanctions. And so you just really need to be careful about that. We got a question also about when the disclosures are due. Is this under all levels of discovery or just level 1 or just level 2? And this rule is an overarching rule that applies to all levels of discovery. In fact, I don't even think that the levels in Rule 190 mention required disclosures. So this is in addition to the Rule 90 level discovery that you're required to do.
Real quick on that,
yeah.
And then I want to jump it over to Judge Purdy, but the discovery periods, the discovery periods now, level 1, 2, and 3, the rules all now say the discovery periods begin initial disclosures are served. So they are now the triggering event for discovery. And before I toss it over to Judge Purdy,
I was just going to add that it is true that the first of the initial disclosures is due within 30 days after the filing of the first answer, but after that, they're due 30 days after a defendant is joined or served. So the deadline switches depending on who you are and when the answer gets filed and what happens. So be careful about that too. It's not for everybody. It's not 30 days after you answer. It's very different.
So you really have to read this rule and know your case. Judge Purdy, before you make your comments on this one, I did want to toss this other question out to you. From a young lawyer's perspective, I have been the dude who's been asked, please write the motion to exclude, or please write the response to the motion to exclude. Is this an invitation? Would a best practice in an area where we have a dearth of case law on this issue? Should we start pulling Northern District of Texas cases, citing Rule 26 and saying, hey, these look similar, and this is how the court should go, in addition to other comments you'd like to make?
I do think that since the rule has been federalized and modeled after that particular one, that we should start pulling those cases as, this is persuasive case law in this particular area. So I think as a young lawyer, that is a good practice tool to have. I do want to make sure that we understand with these disclosures that, a party isn't going to be excused from making its disclosures because it has not fully investigated the case or because it challenges the sufficiency. At the beginning of litigation, I think the practice is to just, let's throw every cause of action in there that we possibly can. And we'll worry about that later. We'll whittle away whether or not it's fraud, conversion, unjust enrichment, quantum merit, we will whittle those things down. I think it's trying to streamline that process. Again, the good intent, but that duty to investigate is coming at the beginning as opposed to in the middle or while you're in litigation. So I think you have to be very careful about that. And you do not want a motion to exclude because you have not turned something over, you have not supplemented, because really the state, I don't have any discretion. You didn't supplement, you didn't turn over, you can't use it at trial. It's just that simple.
Well, and also don't forget that, okay, let's say that I make an initial disclosure and I have done the best I can with what I have at the beginning. And then 5 months go by before we take the first deposition. Let's just pretend I'm not doing this off of any actual deadlines in the rules. This is how stuff goes. So it's 5 months before we take the first deposition, and I'm going to take the deposition of the plaintiff. I'm representing the defendant. I'm taking the deposition of the plaintiff. And stuff has come to light in those 5 months. Documents have happened, emails have happened, stuff like people have gathered documents, and that includes the plaintiff. And the plaintiff doesn't supplement their initial disclosures. And at the deposition of the plaintiff, which I spend all my deposition time taking because I already have a lot of stuff, I learned that I don't have document A, B, C, D, I don't have stuff that I really need. I'm going to go ahead and finish asking the questions I needed to ask, but then I'm going to the court and I'm filing a motion under Rule 215 to allow me a second bite at the apple with that plaintiff. And I'm going to ask for the plaintiff to be required to pay my attorney's fees for it, because there were a lot of documents that should have been disclosed in initial disclosures. And now I'm going to have to spend more time, getting a second deposition to talk meaningfully about those documents. So it doesn't have to necessarily be that you're going to get something excluded from trial or that you're going to get a death penalty sanction. These could result in smaller sanctions. But again, this is a really difficult thing to explain to your client, that this was a requirement under the rules and you just didn't do it. And a judge said, look, I'm going to let him have 4 more hours with the plaintiff, and I'm going to require the plaintiff to pay the defendant's attorney's fees for the deposition. And maybe that doesn't happen all the time, but again, you just don't even want to have that conversation.
And I think that, as Kirsten has mentioned, that is a difficult spot to be in, telling your client, okay, we got to redo a deposition, and we have to redo it based upon something that I did not do. So you don't want to be in that position. And I think it's more than reasonable if you go to court with those particular types of facts, that a judge will order another deposition to occur, and for that other side to pay the attorney's fees and the costs associated with that deposition, having to redepose.
Well, what's interesting about this, before we turn to our next topic, is that I feel like the Texas Supreme Court has just changed initial disclosures. And now we have talked about everything from moving for sanctions to get a second bite at a deposition, all the way to trial exclusion. This is a huge deal. And I think that the prudent practitioner needs to pay attention to these initial disclosures from day one. And as Kirsten said, throughout the process, because we have old instincts. Some of us who are, the ripe old age of 33 here, we have old instincts like, well, I sent you a request for production. I produced it in response to a request for production. That's good enough, right? Well, that's not the same as putting it in your disclosures. This is a huge issue. And so young lawyers being on the front of this, we need to make sure we're paying attention to this. We're reminding our partners and the associates we supervise about these issues, that they have far more reaching effects that we would ever think. And Judge Purdy and Kirsten have just come up with 5 of them here in the last minutes.
And it's a great way for you as the young lawyer to make yourself invaluable and to make yourself a valuable part of the litigation team, because Andy made the joke earlier about nobody on this call thinking that the 1999 amendments are the new rules. I do. As somebody in my 50s, I'm in that category. And so, I, as the nerd, the appellate nerd, I do pay attention to the rule amendments, but a lot of people my age and older don't. And so they're going to be generally aware, but they're not going to be specifically aware. And this thing that we just talked about is a huge issue, just like Andy's saying, because now you're not just checking to see, do I have a duty to disclose this document because somebody asked for it? It's, I do have a duty to disclose this document if I plan on using it in any way at trial. So older lawyers may not know that. You, as the young lawyer coming in behind and being the safety net and saving them from their own ignorance, that's huge. And you can be the person who everybody wants to have on their team because you're up to the minute on it.
So in an effort to get to expert disclosures, I want to drop on one topic real quick, because I have the infamous privilege of doing this panel right after the first of the year and telling a defense lawyer to come at me, bro, on this issue. Ultimately, we figured out how we were going to do this and no one came at me. But the rules now specifically say that you can't send written discovery until initial disclosures are done. So this is a trap. Admiral Akbar standing right here in front of you. It's a trap. You're going to forget to send written discovery until you're the night before the plaintiff's depot or the defendant's depot. This is a problem. So the prudent practitioner needs to calendar and schedule that you need to send written discovery immediately after you do your initial disclosures, because you can't send it before then. Now, my argument was, well, I can send it before and it's just not due until after you answer initial disclosures. But there is an argument to say, if you send it before, you can even send it, and discoveries, the rule says you can't even send it, I don't have to answer it. And so this is a trap for the unwary. Calendar your need to send written discovery after initial disclosures. To the live question real quick before we move on to expert disclosures. These take effect for cases filed after January 1, 2021. So if you're still working on your 2017s, 18s, 19s, and even 20s, these rules don't apply. So if cognitive dissonance wasn't a word you knew before, you now know it. Old rules and new rules mashing together in your head about what you have to do. Be careful, be careful, be careful. So turning now to our last topic, because we've got about 15 minutes. This is an area that I want to call specific attention to one part of the rule, but again, the learned judge and our learned appellate counsel are going to come up with 10 different ways this is a problem. I guarantee you. So we're going to be talking about this a lot. Expert disclosures have changed. Expert disclosures, again, like initial disclosures, there are requirements. If you're going to use a testifying expert, there are a number of things that you didn't have to disclose before that you do now, like a 10-year list of publications, the 4-year list of places that they've testified, and a statement of compensation. Again, this is quasi-federalizing this rule. Additionally, this is all Rule 195, Rule 195.5. There are some new things that you can't get anymore that are much like the federal rule. Before, expert communications. If I'm emailing with my expert doctor, you get all of those communications. Now, you only get communications that don't include identifying facts and data or identifying assumptions the expert will rely on. I bet Judge Purdy is going to see a lot of stuff in camera, but to decide whether or not it's facts or data or assumptions. And then the other new change is that draft expert reports, just like in the federal system, are no longer discoverable. So we have these new contours. I want to toss it over to Judge Purdy first, because I did mention that I feel like you're going to be seeing a lot of motions about whether or not this communication is facts and data or assumptions, or is it just me scheduling the depot or whatever. But the larger thing I wanted to talk about is that, are these communication protections and expert report protections, are they a privilege? Are they a complete exclusion from discovery? How should we go about interpreting that as practitioners?
Well, I thought about this a little bit more after we had our prep on yesterday. And so I want to make sure that I make this particular disclaimer while I don't give advisory opinions. Just speaking in general, I would treat this as essentially not a privilege. I feel like if they wanted it to be treated as a privilege, they would have put the word privilege in there, much like we already know the attorney-client privilege, work product privilege, those are specifically in there. Now, I say that to say that is probably based on my experience. For the past 7.5 years, I was the associate judge here in our civil district courts where I heard primarily discovery disputes. And the way that I started all of those discovery disputes on motions to compel were essentially relating it back to that pleading and the causes of action and lining that up with the discovery that was being requested. And so it was my job to determine whether or not the discovery that was being requested of a party, if it was in the scope of that pleading. Now, whether or not you are trying to add some additional pleadings, or additional causes of action, if it wasn't asked for in that pleading, my job or my opinion was it was not within the scope of discovery. So I think I look at it more of a scope issue as opposed to a privilege issue. It's interesting because I think, obviously there's some ambiguity there, but I just feel really strongly about if they wanted to put privilege in there, they would have done that. There's a lot of things that go on when you assert a privilege in discovery. There's other rules that get triggered, whether or not I can test that privilege, whether or not I can what are we going to do? Ask a privilege log for your expert report and test it when we get there to court? I don't know, but I know that's how we typically handle other privileges under the rules. So that's just my thought on that particular issue. But I know when we talked about this yesterday, Kirsten had some good points to pull up as well with regard to this particular issue.
Absolutely. Kirsten.
Unmute, sorry. Yeah, just really quickly, I tend to agree with Judge Purdy about whether this is a privilege or an exclusion from the scope of discovery. But I think you can make arguments either way. And I can't predict which way it will go. And obviously you can get different trial judges who view it different ways, and different courts of appeals that view it different ways. So we may have a little bit of uncertainty about this, but I do think that what is clear from the rule is that these things are meant to be excluded from any sort of discovery requirement or ability to get them. And so, and I don't think that there's any indication in Rule 195.5 that you are required to assert privileges, in a privilege log or something like that with regard to these particular documents. So I don't know that there's a bunch of traps that you would get trapped into, but obviously trial judges differ. So know your court and know your audience. I think that also leads to the point that practitioners are best served in dealing with all of these changes by trying to comply not only with the letter, but the spirit of these rules and the amendments and what they were aiming to do. They were aiming to, make discovery more friendly and getting more information out without having to request it or compel it. And they also, with regard to these expert reports, were aiming to make more clear what you don't get, so we don't have fights over that. If Andy sent me, requests for production along with his original petition, yeah, I would have an argument that those are just void and I don't have to deal with them. But what busy trial judge like Judge Purdy is really going to entertain that seriously when all I had to do was basically send Andy a letter back saying, look, I don't have a duty to respond to these until 30 days after I send you my required disclosures. So I'm going to be responding on this date and paper that up. And then, to repeat Andy's saying, come at me, man. I mean, take that to Judge Purdy after I've already provided these to you, and try to get her to sanction me for just doing what the rules said they should do when what you did wasn't really under the letter of the rules either. I mean, just common sense here. Let's not overburden courts, particularly post-pandemic, with a bunch of motions that really, what are we arguing about? Can we work this out? That's what we're supposed to be doing. So I know that it's a revolutionary concept to some trial lawyers, but I do think being the voice of reason and framing it in terms of we have to be in this court for quite a while, guys. We don't want our first appearance in front of Judge Purdy to be something where we're arguing over an issue that we could have resolved ourselves. That is not the best way to appear before her first, okay? that has a lot of pull with older lawyers. So be the voice of reason. Don't be afraid to make those suggestions, and to, make a very compelling case when it looks like there's really no reason to fight about some of this stuff. One thing as the appellate lawyer that I have to tell you though is, in terms of the expert report, the drafts, I don't think there's going to be a lot of dispute about what's a draft and what's not. But in terms of the communications that are protected, you see in subpart C of the rule, there is a list of exceptions of what communications aren't protected if they relate to compensation, identify facts and data that the attorney is giving the expert to rely upon. I would imagine that within debates about that and motions to compel, there's going to be in-camera submissions. Be aware that just because you submit something to the court in camera and the court reviews it, that doesn't mean it gets to be part of the record. You have to still make it a part of your record somehow. And sealing these things can be very difficult. If you are in any way thinking you might need a mandamus, or you're thinking that you might want to appeal this ruling on appeal, you need to figure out a way to make that part of the record, because just giving it to the judge in an envelope isn't going to do it.
Well, and I would also add that two parts to that. One is that the prudent practitioner on these rules recognizes what you're saying, that this is trying to be a more open discovery practice, and that if you're saying that I only have to give you a description by category and location of documents, that's not going to play well when I move to exclude all your evidence at the end of the case because you told me it's in a file cabinet at my corporate headquarters, documents pertaining to the employee file. That's not going to be good enough. I really feel that's not going to be good enough. But the other thing that I've been hearing from the both of you, and having worked through this panel before, is that I think a lot of old instincts and a lot of don't be a jerk instincts are probably the way to handle this. For example, on the communications, identifying facts or data or identifying assumptions for an expert, I think we just have to figure out, and just everything you send to your expert is potentially disclosable, because the other side's going to come at you for it. You're going to have to give it to Judge Purdy, and she's going to read it, and she's going to know. And so from a practitioner standpoint, the old instinct of everything is discoverable, that's not a bad instinct to keep going. And Judge Purdy's comment about how she goes to the scope of discovery when making these decisions, that's a fundamental rule about discovery in our cases: what's in, what's out based on scope. And so these higher arching themes are probably the most important in dealing with these new rules. With the 5 minutes that we have left, I want to turn it over to Judge Purdy to offer if she'd like to talk about anything else we just talked about, or if she'd like to add anything new, and then you can also have a chance to close up again. You'll be playing if you get to open and you get to close.
Sure. Well, I appreciate that. I did want to add another rule that has been amended, and I think maybe the younger lawyers will find this most interesting, and can also possibly create a niche practice from that. And that is the substituted service under Rule 106. It's basically saying now that, you may move to ask a court for substituted service. I mean, we all know that people try to avoid service, but how exciting is now you're going to be able to serve people on Facebook, Instagram, and Twitter. I thought that was really interesting. Some due process concerns, obviously, that the court will have to balance. How do we know someone regularly uses their social media? How do I know that's actually them logging on? That type of thing. I'm on social media, and I had someone send me something the other day. I think this is someone is impersonating you on Facebook. They've created a bot. And I had to ask my son, who's 15, what is a bot? And he says, oh, someone's, scamming you. I think that's interesting. I think it's a niche practice that young lawyers can obviously do very well on, because this is sort of in their wheelhouse. So I'll just add that I think it's interesting that we have that on the horizon. And I don't know if Kirsten wants to add anything to the whole Rule 106 substituted service and how they've expanded that.
I think you're right. That is an area where young lawyers can be up to the minute on not only what you're going to be required to establish in order to get that approved, but also what kind of evidence you're going to need to back it up and how to make that evidence admissible in court, because it's going to be stuff from the internet. It's going to be online resources. It's going to be things like that. So it is an interesting area. I would keep an eye out for articles and different things in the head notes, DBA head notes, and the Texas Bar Journal and CLEs that you go to. Just have a little file folder that you can have. So if a partner asks about that, you're up to it.
So the secret question then to both of you, pulling the secret question out here, is if there's a mistake you've seen or something really good you've seen a trial lawyer do in any area of discovery that you think might be apropos to our discussion here, now, share it with the class. If not, this is the opportunity for final thoughts. I would say that as far as a young lawyer and a practitioner, the scheduling order is great. Put everything that's new and different in your scheduling order and run that track. And then I would say that you should get a friend or a mentor to run a lot of what you're doing by, just generally. But in these cases where you're talking about, well, should I email the expert this, or is this discoverable, or this, that, or the other? If you say it out loud to somebody else and it sounds like you're Better Call Saul, don't do it. But you need a friend to do it. Mm-hmm. So Judge Purdy, Kirsten,
just sort of the practice tips for your young lawyers that are on this particular on the webinar today. My show and tell sort of type of moment is to indulge the court when you really need to indulge the court. Reputation is everything. And if you need to be in this court for a long time, indulge them when you need to indulge them. So that's one particular thing. And then the second particular thing is that scheduling order is your friend. When someone tries to do something outside of that scheduling order, if we're still in remote hearings, or if we're in remote hearings, obviously share your screen and share with the court, this is your order. They have not shown good cause as to why they should violate an order that is already in place. That's one thing. If you're in person, use that as a demonstrative guide, blow up that order to show this is a scheduling order. It's an order. It's not a suggestion. You have ordered us to follow these particular guidelines. And that's a high threshold for someone to jump over good cause to show why they should go outside of the scheduling order. Those are my two show and tell caveats.
This is definitely from my experience as well. If you find that either you or someone else on the case has made a mistake, particularly in complying with these new amended rules, take a look at that immediately. Run through in your head all the different options that you can think of what to do about it and what are the possible consequences of each option. And then go to your partner or whoever is the person in charge of that case, or whoever's next in the hierarchy, if that is more appropriate, and talk to them about the problem that you found and the options that you've already developed as potential problem solvers. You don't need to be proactive in terms of like just picking up the phone, calling opposing counsel about it, because that may not be the best route immediately. But it is much better to know about a problem as early as possible and to figure out the best way to address it and then just do it. And segueing into the indulging the court, sometimes the best option is to be forthcoming immediately, not only to opposing counsel, but to the court, and try to get everybody on the same page as early as possible, be proactive. And that generally is not going to do you wrong. I mean, the worst thing that will happen to you is probably better than the worst thing that was going to happen to you if you just sort of sat on it and did nothing.
Well, then that sounds a lot like the advice I got from one of my mentors, that things you disclose can embarrass you, things you hide can get you in trouble, only embarrassment heals. Or as I like to tell my kids, all problems can be fixed if we talk about them. So it's 1 o'clock. I want to remind everyone that the CLE number is in the chat bar. I would really like to thank, in fact, I do thank Judge Monica Purdy of the 95th Judicial District Court and Kirsten Castaneda, outstanding appellate extraordinaire. Big round of silent Zoom applause. Thank you both for being here today. I look forward to the brave frontier of these rules. Thank you all out there in webinar land. thank you to the DAYL for this opportunity today. So with that, Your Honor, are we excused? Is court adjourned?
We are adjourned. Thank you.
Outstanding. All right, we'll see y'all later. Thanks so much.